All right. So good afternoon and welcome, everybody. My name is Marissa Bluestein. I'm with the Quattrone Center for the Fair Administration of Justice. This is part of a monthly series of trainings that we put on for attorneys and others in the post-conviction litigation space. This webinar series is funded by a cooperative agreement with the Bureau of Justice Assistance through the Upholding the Rule of Law and Preventing the Wrongful Convictions program. So this month is a topic that we've been wanting to put on for quite a while, because we get a lot of questions about this, which is how to evaluate and review cases involving potential, convictions based upon shaken baby syndrome, or as we now know it to be talked about as abusive head trauma. So I asked both two folks who have a terrific experience in this to join us to help us kind of walk through, both from the perspective of the defense lawyer, which is Mark Freeman, who's in private practice. He has a national practice actually trying to look at cases and work with parents who have been falsely accused of child abuse, which kind of led him into this area. And he is now a national expert and widely sought after for his expertise. And Sunny Eaton, who is the head of the Nashville District Attorney's Conviction Integrity Unit. Many of you may have seen, and I'll put soon a link into the chat, a series from the New York Times Magazine on a case that Sunny was involved with as a prosecutor, where she was working to overturn a conviction with the Tennessee Innocence Project of a gentleman named Mr. Mays, but the court did not agree to that relief, unfortunately, and now the case is on appeal. But through that, she and her team have gained great expertise in how to evaluate these cases, look at them, and today we're here to obviously give folks some information about that. So first of all, thank you both, Mark and Sunny, for joining us. Very, very happy that you can be with us, and Happy New Year. So I want to start by finding my cheat sheet up here. And please correct anything that I may have said wrong in terms of introductions. But I want to we'll take everybody kind of through this and looking at it both from the defense perspective as well as prosecution. Mark, the case comes in, you've got a client who comes in and says, I've been accused of this. My loved one was convicted of this crime. They didn't do this. I don't know what to do. What's your first step? How do you start evaluating that case?
Well, first thing I usually do is refer them to an nearby innocence project. But as far as what I do to review a case is I'm a big believer that I have to have probably a better handle of all the medical records than the doctors who testified. And I think when you're looking at post-conviction, you have to really, I mean, obviously the issue is what has changed? What are the big changes? And there's a lot going on in the shaken baby world. I think if you have a case that involves a short fall, I think that the American Academy of Pediatrics has done a 180-degree on short falls from 2000 to the present. So it depends on when the conviction occurred and kind of what was committed to at the time of trial. How many layers of complexity do you have? Is it a subdural only case? Is it a subdural and retinal hemorrhage? Is it subdural retinal hemorrhage and some kind of brain insult? Obviously, do you have a dead baby? Do you have a living baby? Do you have anything in the neck? Do you have bruising? Do you have fractures? And so in a lot of ways, when I first look at a case, I'm kind of trying to classify it. And is this a straightforward kind of shaken baby case, or do you have these other things that they can point to that are alleged to be indications of trauma? And that's always the big issue: is there really trauma? And the more of those factors that you have, the more difficult it becomes to argue that it's not trauma. Now, if you have a short fall or some minor trauma, then it's a minor trauma case, and that's a whole different issue. That's where I start.
Just for folks who kind of may know that this is a potential issue, but you mentioned about hemorrhaging and others, could you just kind of give a very brief-ish explanation of why those are the factors you're looking at initially?
Well, sure. I mean, anytime if the invocation, we're here to talk about shaken baby, abusive head trauma cases. In 2009, the American Academy of Pediatrics tried to muddy the water between impact cases and shaking cases. I mean, impact is impact. My undergrad's in mechanical engineering. So, if you have impact, impact is impact. If you do, the Nutcracker ballet before your head hits the wall, it's your head hitting the wall that matters. The reason we get into these cases with shaken baby is because generally there's no evidence of impact other than the presence of a subdural hemorrhage and or retinal hemorrhages, and then possibly some kind of brain insult, infarct or axonal injury. That's what drives the abusive head trauma, shaken baby prosecution and controversy. And I don't know how much you want me to get into the detail of what exactly a subdural.
Nope, that was exactly what I was looking for. Thanks. Just to kind of
center
where we were.
So the big thing here is, you got your scalp, the skull, and then the brain. But in between the brain and the skull, the brain is actually covered by this thing called the dura. And it's highly technical, and there isn't really a subdural space. But this covering of the brain called the dura can tear, and it's not even a good cleave is a better word that the doctors use, is that this tissue cleaves, and then that area where it cleaves can be filled with fluid, or it can be filled with blood. When that area is filled with blood, it's technically outside of the brain, but inside the skull, a lot of times it'll be called a brain bleed. But if you get precise, it's not really bleeding in the brain, it's bleeding outside of the brain in this thing called the dura. And there's like an immediate assumption in anywhere medicine has taught for the past 50 years that there's a virtual immediate assumption of A, trauma, if there's subdural hemorrhage, and B, if there's no evidence of impact, then it's shaking. And I time and time again, what really drives these cases is the presence of subdural hemorrhage. The presence of retinal hemorrhage just supports the diagnosis or their belief that it's shaking. And then if you have anything else, brain insult, brain injury, neck injury, bruises, rib fractures, that all supports it. But what really drives it is the presence of this subdural hemorrhage.
Great, thank you. And then Sunny, same question on your side. A defense lawyer or applicant contacts your office to say, I was convicted. Doctor said it was shaken baby syndrome, abusive head trauma. What are your first steps as an evaluator from the prosecutor side?
Yeah, we're doing something a little bit different. And I will say right up front, having talked to Mark before, he is brilliant on the medicine. I am not. And I don't pretend to be. So we put a lot of safeguards in place to make sure that we fully understand it enough to know what we're doing as we go along. Also, thanks for having me. And it's really nice to see so many of my favorite people on this call. I want to point out as well that Anna Hamilton from my office is also on this. And Anna was the lead investigative attorney for this case. So if I get in trouble with anything, I will refer to Anna as well. But for us, when we first, and we had 2 or 3 of these come in last year that we had, over the last 2 years that we had to look at. And we only took on the one case that the New York Times covered, which was Russell and Kay Mays, his wife as well. And at some point, I do want to mention the factors that went into Kay Mays, the wife, because I think we see a lot of couples come into these situations and there's so much rampant bias, sexism, and frankly, witness coercion that takes place with the spouses that I think it's worth mentioning. But for us, we start with the transcript. We start with the trial transcript, and what we're looking for when we go through the transcript is what actually convicted these people. Not what the state's theory was, not what the defense theory was, but if we were sitting there as jurors and we heard this evidence, let's note, bullet point list, what convicted them. And I think for us, it certainly was for defense lawyers that we've worked with on these. It's very easy to get lost in all of the medicine and all of the science and go, well, I'm not qualified to take this, or I'm not qualified to look at this case. It would be nice to have a specialty just around this, but certainly from a prosecutor's office and most defense lawyers, we don't get to do that, but we've got to become as much of subject matter experts as we can. So when we're looking through that, we start as lawyers. We start as lawyers in the most basic of ways. And honestly, for this case in particular, the medicine was huge, but what we learned as just lawyers doing what lawyers do really is what told the story of this case. And what do I mean by that? What are the timelines? A detailed timeline is where we started. And that timeline, though, goes a little bit beyond the obvious things. I mean, you have a burglary case, you know what time a window gets broken into, you know what time the police showed up, you know those things. On this case, it's a little more complex than that. We didn't have to, at first look, understand what the medical records were saying to develop a timeline about when they were developed. When were these notes made? When was this information passed along? What happened after this information was passed along? How was it passed along? What's the impact of that? For lawyers who are getting really lost and, oh my gosh, there's so much medicine here, I can't even look at this case without the experts, start simple, start with what we know, because that kind of information can actually guide what you need to know about the medicine. In the Mays case, for example, a lot of where we got to turned on which tests were actually done and which tests were available at the time that the diagnosis was made. What we found was, I mean, there's loads of tests, there's loads of notes, but when you look at when the diagnosis was made, it was made within just a couple hours of this child coming into the hospital. Well, a lot of these test results didn't come in for a couple of days after. So as a lawyer, I don't need to know anything about what was in those records to make notes of those kinds of issues. And then we'll talk later with our experts about how those issues had impact. You know, there is a certain just getting organized in these cases that makes a big difference. One thing that when we're looking at these timelines that we are looking for as CRUs and as innocence lawyers are the bigger pictures here as well of where might it have played in? And when we're looking at the medical records, it's a tremendous deal. What we learned through this, for example, was the way that a test is ordered matters. What is put in the order matters. And this isn't defense mumbo jumbo. I was at a Department of Justice training. Lorna was at that training last year. And one of the things that one of the pathologists said right then was that you can have 3 different pathologists look at the same slides and come up with 3 different opinions. That was DOJ training a bunch of prosecutors on how to do this. And they told us that some of what impacts these kinds of looks is what they're told. And we learned that about radiologists in particular. If a radiologist is told they're looking for sepsis, they're looking for sepsis. If they're told they're looking for trauma, they're looking for trauma. It has a dramatic impact on how these things are read. And expert after expert told us that. Now, I will tell you that the judge was unimpressed with that argument, but it's not an argument. It is a well-accepted fact among medical professionals that what they're told and how these tests are ordered impact how they're read. It impacts what's looked at and what's missed. And certainly in all of our personal lives, we can come up with those kinds of examples. So I struggle to understand why that's such a hard concept for the courts. But when we're originally looking at a case, we are looking for what is the story here, what is the timeline, and how did this happen, and what actually convicted these people. So, I mean, and for us, regardless of the medicine, we're a DA's office. If we had found rampant evidence of abuse, if we had found multiple complaints by or concerns from neighbors or friends or family or coworkers that these people were unfit, that could have turned our investigation. Honestly, it could have ended it very quickly. And that has nothing to do with the medicine. So we're looking for a much more holistic picture. Once we've developed that picture and there aren't red flags that we need to do diligence about in the whole picture, then we dive into the medicine. That's the next thing. And for us, that next thing with voluminous medical records, I mean, we are talking about thousands of pages. I'm not qualified to do that. I don't care how educated we are. I'm not qualified to go through 30 years back of medical records from multi-professionals, multi-agencies, and then get it right. So along with this, in this one, the Innocence Project helped us out, and they actually hired a nurse who could do that. And she made a very organized, wonderful chart for us of every single document that existed, why it was relevant, what date it went, and who the doctor was. And that really helped us as a guide. And certainly we added to it and took away from it. That is easier when we're working in partnership with other people. I think the power of the state is often overstated in terms of our budgets and what we have access to, especially as a CRU. We don't have access to the same resources. We simply don't, that we do with open cases as line prosecutors might. So we start where we can. And for us, we start with the transcript, we start with the story, we start with the timeline. We ask ourselves, does it make sense? That's where we start.
Okay. And Mark, I'm wondering if you could kind of comment a bit on what Sunny was saying in terms of the testimony at the trial that convicted the individuals. We talked before, and I think you talked about this as, was the expert committed to a particular theory? Has the science changed? Is there bias, as Sunny was mentioning, potentially incompetence? How does that kind of figure in to your initial analysis?
Yeah, I mean, one thing I run into a lot is when you look at the reports that are written by doctors, they oftentimes are very non-committal, suspicious for, concerning for, but when you look at the police report or when you look at their testimony at trial, they're much more definitive. And that's where I start looking, did they commit, when I'm preparing for trial, did they commit in the preliminary hearing? Did they commit in their reports? And what did they commit to when they talked to the police officer? And obviously in a post-conviction case, you have to look at what did they commit to as, again, I come from an engineering background. I want them to commit to a mechanism. The big thing I see with in this abusive head trauma thing is they don't like to commit to mechanism. That was the whole point of it. I find that personally offensive. What do I have to defend my client? What did you accuse my client of doing? And they'll say, well, what I love all the time is well, it's shaking with or without impact. Well, doctor, is there evidence of impact? Well, no. So you're speculating that there was impact, and you do this round and round. But is that answering your question?
Yep, absolutely. And Sunny, you said you had one more point, and then I want to ask about confessions here.
I do. One thing also that was really critical for us in this case that I think would have been easily overlooked to look at when you're first looking at these and you're looking at all of the records is what ideas were just accepted in procedure and procedure after procedure without any actual evidence being provided or continuing throughout the record. So for example, in the Mays case, there was a lot of discussion. And honestly, I think this is one of the things that really convicted them. There was a lot of testimony about things being ruled out, a lot of testimony about that. And with this kid in particular, cardiology. That was something that we noticed relatively early in the case that was pretty nuanced. I'm actually really proud of my team for getting to this, but we noticed throughout the record, a lot of the reasons that they said this had to be abuse was because so many things were ruled out, including cardiology. Now, one of the early things we did with diligence is we checked as many backgrounds and for lawsuits and things as we could for every single doctor that we found. And frankly, the cardiologist who worked on this kid had a great reputation. There were very few complaints. We had people in our office who'd used them themselves. So we were trying to figure this out because all the testimony by these other doctors said that cardiology had been ruled out as a problem. So we go to the cardiologist record. That's not what he said. That's not what he said at all. What he said was there's actually a lot of alarm bells going off here, but at this moment, there's not enough for us to really do much else. We need to put a Holter monitor on this kid, watch him. But even if that's okay, in 6 months, in a few months, we need to come back and do it again. And if something comes wrong with that, then we have major problems that we need to look at. But at that point in time, when he did that first initial examination, he was like, there are alarm bells, but not enough. That wasn't ruling out cardiology issues. That's a very different thing when a doctor says we actually need to come back in a few months and do a whole nother Holter monitor study. I mean, there's some concern there, but that was translated by the original diagnosing child abuse doctor as cardiology was ruled out. And that narrative followed both trials, followed PCR, followed us all the way through. So again, whether you know the medicine or not, as lawyers, what we have to be doing is asking the question. When someone says something like that, let's go find the record that shows that. That came up a couple other places in the Mays case as well. Sepsis was one of the original differential diagnoses when he came in. That was ruled out. No one considered that this kid was given antibiotics the minute he came in. The blood tests were done later. Of course, sepsis would have cleared up some then with the right antibiotics. There were bleeding issues with this kid. Later on, bleeding issues ruled out. No one considered he had a blood transfusion. when he was in the ER, which could have cleared up or tainted some of those tests. And then we learned things from our experts later that even the type of blood that was given can influence how these tests turn out later on. We didn't know that. And there was no documentation in the medical record of what type of blood was given. Really relevant information. I don't have to know a thing about medicine to do a little flow chart and go, this was who said this. How did they get there? So I really wanted to add that. And the one thing, and what Mark just said, absolutely true in the Mays case too. Although the state really argued shaking throughout the trial, in the closing argument, they made this, it could be slamming on something, could be shaking, which is what that consensus statement that we'll get to really does, I think, for prosecutors' offices, that the defense lawyer in me does find patently unfair, particularly in a case like this, of saying, well, it's either shaking or slamming. Because you think about that with a jury. There's a very different impact on a jury who might be able to understand or conceptualize some kind of scenario with a tired parent, or one who's maybe reviving a child and overshakes them, whatever, to try to do that, than the idea of a parent slamming their child's head on something. Dramatically different impact on a jury, dramatically different impact for defense strategy. And right now the courts are just allowing the states to not commit to this election. And that's where I actually think a bill of particulars would be a really important thing to file early in these cases.
Yeah, and I want to echo what Sonny said about hematology. I had a case where I had a doctor run the recommended hematology workup. But if you read the American Academy of Pediatrics article that recommends those, it tells you specifically it will, even if you run those general screening tests, you'll still miss platelet function disorders and less common bleeding disorders. And also, if you get into genetics, which is a whole different field, you know, they ruled out hematology, they ruled out genetics. I had a case one time where again, I echo what Sonny said with the bias. I'm sure this is the conversation. The child abuse doctor calls up the geneticist, hey, we have a case of abuse here. We need you to rule out the genetics.
Right.
So this doctor comes into the child's room, does an examination, and says no need for genetic testing. A couple days later, a neurologist believes the parents, runs this battery of tests. The child abuse pediatrician actually writes in the note that they opposed the testing. Long story, ultimately the testing comes back. The child had a mutation. And here's the crazy thing. The mutation wasn't really well known in the world. You know, we're learning a lot in genetics. But at the hospital where this child was one of the leading clinics on that particular mutation. And the doctor that walked into the room and said there was no need to do a workup was the head of that clinic for that particular mutation. Wow. So, you know, rule out genetics, rule out hematology. I agree with Sonny. You take a hard look at that because the bias is there. They don't want to waste their time. They already believe it's a case of abuse, and they just want to move on and give the doctor what they asked for, which is, I can say there's no need for any more workup. There's no concerns here.
Yeah, and in our case too, again, with a lot of these ruling out things, and we're so glad that we got some of the experts that we got, they would say, well, we ran all these tests, we ran all these panels. Look very carefully at what was available back then, 25, 30 years, versus what's being run now. It is incomprehensible that, of course, we don't have different ideas for what and how to test things now than we did in these cases that are 25, 30 years ago. But the court is still accepting these ideas of they did all this testing. It was ruled out. This is standard. And in fact, we just had the original prosecutor on our case try to file an amicus brief, and this is part of what he talks about. He says, well, all these things were ruled out. All of this was done. The CRU doesn't know what it's talking about. Hey, look, I'm not pretending to be a pediatric hematologist or whatever, but I can tell you that in 2024, there is a very different panel of genetic testing that's done automatically than was done back in 1998. I can tell you that. I can tell you that clearly. And how you can't consider that maybe there are things we're looking for now that we just wouldn't have looked at then is just beyond understanding to me.
And just before we move on to kind of thinking about how do you gather and analyze the materials once you've decided to take the case forward, many of these cases do involve confessions. We've talked quite a bit in these trainings about the potential that confessions can be false, can be coerced. Do you put any substance whatsoever into a confession? Do they have any kind of evidentiary value for you at an evaluation stage, or do you just kind of put them off entirely?
No, I will
Mark,
tell you that.
go
Oh, I'm
ahead,
sorry.
Cindy.
I jumped in on that as the prosecutor's office because I think they're very, I mean, honestly, you know, the word confession being used in all of our CRU evaluations definitely leads to much higher scrutiny. And you know, and I am someone who understands why false confessions happen and why people make statements against their own interest or that can be interpreted that way. But still, as a CRU attorney who has to make a presumption that we got this right before I start looking into this, I see confession and all of my alarm bells and flags go off. Now, in our case, though, but we never stop there. It just becomes its own big folder of things that we have to look at and evaluate very carefully. But in our case, you know, it's interesting because there were things that were characterized as confessions in our case. Now, the Innocence Project took a slightly different narrative in their legal filings than we do. And they kind of said that the word confession was used rampantly throughout the trial. That wasn't our opinion. It was used a couple of times throughout the trial. But that word, again, I refer to this amicus brief from one of the original prosecutors because I'm a little amused by it. He defends himself and says, well, we only use the word confession twice. Sure. But as lawyers, that's a nuance that's very different than for juries. You did say admitted. You use that term quite a lot. You say he made inconsistent statements. You say things like that a jury is going to read as a confession. And later on that, again, these narratives they just carry. I had a totally different, unrelated shaken baby case years ago that Nashville just paid a lot of money to this guy. Everyone accepted the word confession from the first trial through the end of the record. It took one look at 5 discs to see that this man never confessed to a thing. But it's the way it was characterized. So again, in our case, what was really frustrating is we didn't make it through opening arguments before the judge was questioning us on, well, did your new experts consider these statements that were made where he admits to jostling this baby? That's what stuck out with the judge who has tried this case multiple times and had multiple post-conviction hearings. I am imagining that's what stuck out for the jury too. But the reality is this father did what I think would have been very suspect for any parent not to do upon finding a child in this level of distress. He admits to picking this kid up and he says, maybe I jostled him. I might have even jostled him as he's trying to help the police officers figure out what happened. Maybe I even jostled him enough to cause some of these injuries that you're telling me can only be caused by that. But I didn't touch him until after I found him in distress. Now, is that a confession? Or is that an honest statement to police from a parent who's trying to figure out what's wrong with their kid and is actually doing something that is what any reasonable person would do and has now been turned sinister? So first we look at, is there even a confession? Is that even what happened here? Because it's very easy to look at a statement like, well, dad admitted that he jostled the kid. He said he might have even shaken him. He said he might have even caused some of these injuries and go, well, they confessed. No. We actually have to go back, watch these interviews carefully, listen to them carefully, see what everyone wrote about them, and then we got to use our brains as lawyers. Now, every so often, there is a confession of some type, but then we got to ask other questions as lawyers. We saw this in our case. I think, Anna, it was Nieves that we watched a parallel video of that interview, and we were shocked by how similar both the questions and the responses were. You get a father who comes in this room. He doesn't understand that he's a suspect. He's helping as the best he can. He's trying to figure it out. Meanwhile, also, his child is dying in a room next door. He has just been told his kid's not going to make it. And what we came to understand, too, is every minute these parents are sitting in there in that interview room, they are not at the side of their dying baby. You tell me who's not going to say whatever they can to get out of that room as quickly as they can and back to their kid. But more importantly for us is one more time, this father's put in a position of being asked questions that really any reasonable husband or father would answer exactly as he did. And he is told repeatedly, only way this could happen, no other options. You had to have shaken this baby or your wife did. So what we saw in the video that we watched in that other case was the guy said, well, look, if you're going to look at somebody, then you look at me. Must have been me because it wasn't her.
Yep. Very it was Thomas was the other case, Sunny.
Oh, thank you. Thank you. It was Adrian Thomas.
Thanks, Hannah.
But it was so similar, the question that was asked and the response. It was so
Mhm.
similar that you have to look at that from a larger context of just what an interrogation is meant to do and what it is effectively doing. This guy, our guy, was put in a position of saying, yeah, either I did this or you got to look at my wife because it must be her. And I want to remind everyone that in these cases that are 25, 30 years old, no one has access to the internet on their phone. We did not have the access to information or the ability, or I think even the foundational thing that we have now that makes us question experts like doctors. This guy is told by the doctors and the police, you had to have done it. There's no other explanation. And so now he goes, well, damn, I must have done it. How did this happen? So that's how this happens. That's why we evaluate these so carefully.
Okay. And Mark, from a defense perspective,
Yeah.
you're not necessarily looking at it to kind of to assume that they got it right from from a prosecutorial bend. What is there a different approach from it looking at it as a defense lawyer?
No, I think you look at it the same way over and over again. I agree with what Sonny said. Over and over again, a revival shake will be mischaracterized as they confess to shaking. And occasionally they get people that say, well, the experts are saying the only way this occurred is if someone shook the baby. Well, then I must have shaken the baby. That's the confession that they get. As a trial attorney, it's just one more thing you have to defend. After the fact, it now becomes a piece of evidence that can support the conviction, even if the science is bad or something's changed. So, I mean, anytime you have a so-called confession, it just makes the case that much more difficult. Although I will say, in the very first jury trial I had in a Shake a Baby case, I actually played his alleged confession to the jury during my closing, because it was a dad who was he didn't know what to do, and his baby went didn't respond, and what do I do? And it's really funny because the National Institutes of Health for a long time had something on their website that said, if a baby's being unresponsive, gently shake them. I've used that in trials, and now it's not on the National Institutes of Health website anymore. So yeah, it's a huge issue, because when like Sonny said, when you look at these interrogations, they're all the same. The detective comes in and he's the doctor. I can tell you that something happened to this child, and it had to have happened within an hour when that baby became unresponsive. So if you didn't do it, then it must have been your wife. Again and again. I mean, there's so many commonalities here.
Yeah.
That's a huge one that you'll probably run into.
Well, I also want to point out in the reverse what we saw and what we keep seeing. Frankly, we even saw it from some of our own experts that we consulted, and it made me cringe every single time because this is so common. But yes, we have detectives acting as doctors, but ultimately, what we have are doctors acting as detectives and as lawyers. What we had in this case, and even with one of the main doctors, she wrote entire papers, has done presentations on why confessions prove the medicine. Well, first of all, confession is a legal conclusion. That is a legal term. That is an assessment for a jury or a judge to make whether a statement was a confession. It's not for a doctor to make. To me, it is clear evidence of role bias, of them conflating their own roles, and then we just accept that they do that. But what they are using, it's this circular argument. Well, maybe the medicine is questionable, but they confessed, which somehow validates the medicine that's questionable. We saw that time and again, which is also one of the things I want to point out too. When you are evaluating these cases before you've learned anything about subdural hematomas and all of those things, when you are looking back at these doctors, also look to what their research is. Look what they've published. We found that the main doctor on this case, while evaluating this case, was in the middle of a research study that she benefited greatly from in her career about these very things. And I don't know how you don't call that bias. I mean, talk about when you're a hammer, everything's a nail. You're actually in the middle of looking for evidence to support this position while you're doing this analysis on this case. And then in a later paper she wrote very shortly after, before the case was even fully litigated, she references the case. She uses it to support her position for her published paper. I actually find that unethical, but I certainly find it to demonstrate bias.
And
so I want to move
I'm sorry.
Oh, go ahead, Anna. Sorry.
I was going to also point out one thing that happened in the Mays case is this doctor, after she spoke to the parents, and then the police detectives, she immediately told the police detectives her suspicions. They came back and then told the doctor that the dad had confessed. And so it just became this like tunnel vision from, she tells the police officers at the scene that there's no way that this couldn't have been abuse. They then go secure this confession and they don't consider any other options. They report the confession back. And at that point, everyone's mind was closed off to any other possibility. It framed the entire rest of the investigation.
And in that, I want to point out, as in how hard this is, that original detective wrote us an affidavit and testified in support of exoneration of these people in our hearing. Also, the original medical examiner who had originally decided this was a homicide, he also came back and gave us an affidavit after re-reviewing everything under the new science and recanted his entire testimony and said that this was an unknown death of natural causes, and no one yet has yet to care.
Well, I would challenge the no one part of that, but maybe no one who can make a decision. So yes, I do want to kind of get to the investigation part as well. But before we get there, obviously these cases involve voluminous records. And I want to start from the defense perspective. Mark, how do you go about gathering all those documents? How do you pull it all together? And are there things that you look for, not for dispositive, but are there more important things to look at than others?
Well, I mean, post-conviction, you're at a much greater disadvantage. You are stuck with the records that were, we had a case I was involved in a case from 1997. The imaging wasn't even digital yet; it was film. So in post-conviction world, it's much more difficult. But when I have a trial and I have a recent case, first off, if I have a parent, I'm asking them to get as much records as they can.
Right.
And in most cases, they can. Although more and more recently, I'm finding that they're being blocked by it, especially if you have a living child and the county agency has custody. They're preventing parents from getting it. But you either have to work through the court, subpoena, court orders. But I want every stitch of, usually these abusive head trauma cases, the kids are pretty young. I want prenatal records, birth records for mom, birth records for baby. I want pediatrician records. I want any hospitalization. Obviously, when the hospital, if you have an autopsy report, all that. I want every stitch. And then critical is you need the raw imaging itself. If there is, sometimes you have dead babies and they don't make it to the hospital and you don't get imaging, but that's fairly rare. Usually there's at least a head CT. And if you have an autopsy report to compare with the head CT, a lot of things can happen in between. You have artifact from autopsy. There's a lot of issues there. So I'm a big believer that the first phase of your investigation is you have to be scrupulous in trying to root out and get every stitch of medical records you can possibly get. I call it looking for maybe 3 or 4 needles in the haystack. If you can find something that was recorded by some third party that had no knowledge of this ever coming, that gives an indication that something else might have been going on, those become the clubs that I can bloody experts with on the witness stand. I believe a lot of the success I've had is just simply due to being very aggressive in the discovery phase. Because when you get doctors to review the case, they're only as good as the medical records you give them. And, sometimes they'll come back and say, hey, I need this. But a lot of times you're the one that really has to be digging in, and anything you see anywhere, you just go get it, because you just never know. Is it birth records? Is it genetic testing? Who knows?
And look, don't forget about the parents themselves, particularly, and again, in our case and another one that we had, one of the parents had better records and better documentation and was able to fill in gaps and things that no longer existed in the record. 9 times out of 10, they have kept and collected all of these things. And in this, we were lucky here. They were very happy to share it with us. But also, you know, a case like this, for us as a CRU, as much as we do an independent investigation, I don't know if we could have done it without the collaboration of the Tennessee Innocence Project, who brought it to us, and the other lawyers that were working on it, because we were all catching different things, and we all had different resources, and we had different stories to tell. We had different goals. They had a legal standard to meet. The legal standard is not the CRU. I mean, we hope that if we believe in innocence, we can get to the legal standard, but that's not our concern. Our concern is what happened here? What are the facts? How did it happen? How can we prevent it in the future? So we are looking for very different things throughout the investigation. And what that means is we're finding different things, and we're calling each other very excited. Hey, did you guys see this? Have you found this? And we're sharing that information. And one of the points I want to make is, for prosecutors at least, I think we were certainly naive about accepting when we have an investigator, for example, call over to the medical examiner's office and say, tell us what all you have. And we say, tell us everything you've got. And they send us something. We believe them when they said, this is everything we have. Well, then later on, when we actually call the original medical examiner, he said, hey, did you guys look at these? Because I would have kept these. So then we call back and we ask for the specific thing, and they do have that. And that was not on the list of things in the, do you have everything? And the person we talked to even said, oh yeah, you wouldn't have thought to ask for that. No, we wouldn't have. That's why we said, give us everything. So, I mean, checking and double checking and checking from these different angles as different parties is incredibly important.
And there's a question in the chat there, which I don't know, either one of you, the pains of using or the importance of access to or getting recuts of histology blocks from an autopsy for that independent review. And I think, Mark, that kind of goes to your point before, that you want the original film or the original test. You don't want a copy of a copy of a copy of a copy.
Yeah, and I think when you go to the slides and the tissue, I mean, I've had pathologists, you know, especially with the lungs or the eyes, they go back and they want additional slides because they feel that the initial autopsy was inadequate. So, you know, again, you just have to, you never know where it's going to come up. What, you know, I always just, it's like, you know, I'm getting a gift when you dig and dig and dig, and then you find that thing, you know, it's what drives me, I guess. I don't know.
Well, and as we're talking about the investigation too, I mean, you know, all the medical evidence, those things, that's incredibly important, and certainly from the defense perspective. But for, you know, the CRU lawyers here or any prosecutors who might be watching, for us, when we're doing that, you know, it's easier for me to talk about a different case that we actually turned down earlier this year. You know, the medicine is one thing, and certainly that's what the lawyer who brought us the case and brought us the application wanted us to look at, because the medicine's questionable. There's no arguing that the medicine is questionable or that there's alternative explanations beyond abuse for what happened. But in that case, as our office and our CRU and with what our duties are, we ask ourselves other questions. And look, I'm not saying that these questions just dispositively close one of our investigations, but there are things that we can't ignore, even if we can explain away the behavior. And in this other case, this defendant had hidden evidence. He had lied to the police. He had delayed getting the child care. There were a lot of things that, as a DA's office looking at these cases, even if I can explain away all that behavior from a young 20-year-old scared guy, it does not make it not exist. And that is very different than the case that we actually took to court, where none of that existed, where everyone was so cooperative and open, and we found no lying and no hiding, and those other things didn't exist. That's a very different situation. But we can't forget, yes, there's medicine in these cases, but we have a lot of other things to investigate as well.
And Mark, so as a private defense lawyer, somebody who doesn't have the resources of a CRU or even necessarily an innocence organization, do you find it as important as Sunny did to get that medical assistance for kind of going through the reports, identifying what they are, or is that something that you feel that you can, with your expertise, handle at this point?
Ask your question again. I'm not sure I fully understood it.
So Sunny had said earlier that one of the things they found particularly helpful was having a nurse who went through all the medical records for them and kind of, this is what this means, here's how this relates. Not even just about the content necessarily, as I heard her say, but just what the report is. Is that a resources that you recommend for folks, or is that something that can be outsourced to
Yeah,
to a nurse or to a doctor or somebody else?
for me personally, probably because I have the experience that I have found, like I've had clients that hired a nurse and did a review before they hired me. And what I find is the majority of those reviews are focused on medical malpractice issues because they get people who predominantly do this in the civil context for medical malpractice cases. And they point out a number of things that were done below the standard of care. I don't find that particularly helpful from a defense point of view. Even if it's an issue that I would probably use in cross-examination, my approach is I have to figure out why this kid died. I have to figure out why this kid had this bleeding, this subdural hemorrhage, this retinal hemorrhage. And even if they didn't do the appropriate testing, and even if they, fell below the standard of care in a whole bunch of areas, if I don't figure out why, that I just find that to be a very much a secondary issue. And in all of the professional reviews that I've seen by nurses, that's the primary focus, is kind of a malpractice. So
Okay.
I don't find that, I haven't, maybe there are nurses out there that can help, but the ones that I've seen haven't been particularly helpful.
Although, Mark, you said a buzzword that I do want to comment on that again. When we were evaluating the different doctors who had weighed in on this case originally, we also asked ourselves who had liability. Because again, like there was a pediatrician who everyone just took the word of everything this pediatrician said. I kept reviewing this kid. Things were standard. Although if you actually look at the records, they were not standard. Well, when this pediatrician is called to testify later in cross-examination, I think it was a major miss on the part of the defense. No one ever questioned if it was you and you missed these things that were very obvious, you would have had liability. It would have been you held responsible. Because for this one case, I mean, there were some very evident things that people looking at these records 30 years later just opened and went, oh, well, that's a problem. But the pediatrician had done a very standard notation, who'd probably seen 20 a day, normal. Well, the question should have been asked, who would have had liability if later on they'd actually admitted to being wrong? That's just part of how we evaluate them.
Okay. So the next big category, of course, is dealing with experts. We've all heard stories about shaken baby syndrome that had 5 experts, 7 experts, 8, in lots and lots of different areas of biomechanics and other kinds of things. So I think, Sonny, we'll start with you on that one. In terms of like identifying what experts are necessary, how did you kind of start that process? I mean, I understand that Tennessee Innocence Project was very helpful for you with that because of their expertise in this area, but you still had to do your own analysis. So how did you as a unit kind of take that on, identify the types of expert you needed, and then work with them?
We did. And as a CRU, those are some places where, I mean, always we're collaborative, but we're independent and we do represent different interests. We may disagree on the number and types of experts, but I know what I have to justify and I know what answers I have to find. So we don't always agree on who the experts are going to be or what types of experts. So we were very careful in our choice of experts that they were objective. We sought out advice from other CRUs, other DA's offices. Who have you used, relied on, dealt with in the past? And sometimes those lists overlap. Certainly with our, on this case, the Tennessee Innocence Project, we had some on the list that overlapped. We both liked as experts. There were some we absolutely did not agree on. I found that in other cases with other lawyers as well. I am pulling other places they've testified. How have they been received by courts? Have they ever testified or found that this is child abuse, that this is shaken baby syndrome, which this will footnote a little bit off track and we can get back, but I don't want to miss this point. Our office has taken a position and continues to, that our argument is not about the larger science of shaken baby syndrome. Right. For us, actually, with this case, and I was talking to someone yesterday that reminded me of this, even if you look at that consensus statement, the one that prosecutors are still using to say this is actually the science has gotten better, it does provide, it carves out exceptions. It carves out exceptions for when this diagnosis doesn't exist. In our case, even if you believe all of the old shaken baby science, he still doesn't fit. We might be making arguments we don't have to be making or that we shouldn't miss by just dismantling shaken baby science. We might not have to, even under what's accepted. In this case, he still didn't meet those facts. But one issue that I have tremendous regret and second guessing about when it came to experts is, what do you do when your experts, who all reach the same conclusion, are not agreeing about how we got there? They're not agreeing about the mechanism or what was wrong with the kid. And I will tell you, every single lawyer, we had a group of about 8 brilliant lawyers working on this, and they all tried to warn me that this was going to be an issue in front of this judge, and I did not listen. I kept saying repeatedly, it strengthens our argument. It strengthens our argument that we have some of the best experts in all of the specialties and they can't agree. So why would we take this one expert who did such a haphazard job? Why would we take her word? They were all right. I was wrong. It was the very first thing that the judge honed in on. And it was slight. In our case, it was everyone could agree on the mechanism, but then there were nuances within it, the type of that mechanism. They couldn't agree on that. And the judge ran with that. Even your experts don't agree. Why should I believe any of it? And this is where, when Mark and I were talking before, knowing the judge is often as important as knowing the science. Our science is solid. Our experts all formed opinions based on their expertise and what we saw in the records. But sometimes, isn't this the point? People disagree. And these cases are 30 years old, often. So it is something to consider when you're reviewing your experts and then deciding who to put on the stand in front of the judge. I think we would have used all the same experts, but we might have, frankly, if everyone had not listened to me on that, we might have presented it in a more cohesive way in court or gone out of our ways to explain their differences.
Right. And Mark, I think coming at it from a defense perspective, when you maybe are looking at it from a change of science as opposed to just an error was made, not just, but on a different level, that an error was made in the terms of the testimony or the diagnosis, how does that impact your question, your ability to kind of get experts? How hard is it? Like, are there kind of easier ways to get experts on this topic? Or is it just such a hot potato that it's difficult to get anybody who's willing to kind of stick their neck out of it?
Well, it's the perennial problem is, I get calls from people around the country, who can you give me experts? And, in the medical world, there are some medical people. I mean, I've had clients come to me and say, hey, I saw the neurologist today and they were telling us they agree. And of course, that neurologist will never testify in court,
Right.
Well, and look, let's not pretend too that historically with this case that prosecutors have not made this terrifying for doctors. I mean, we have seen time after time, even in past cases in our own office, where qualified doctors are testifying to something the state does not agree with, and then they're facing a board complaint. Then they're being called hacks. Then they're being called experts for money. All of these things. And I am not saying that never exists within expert land. We vetted very carefully. But there has been a very strong disincentivization by the state for these experts to take these risks.
Right. And Mark, you agree with that? That's your experience as well.
The universe of doctors that are willing to stick their neck out and take that kind of abuse is pretty small. But even with that, I think, Sonny points out, the more you can get a doctor that has testified for the prosecution or has not been involved in these kinds of cases before. We have a couple of experts that have been excluded by several states one or more times. Then the whole cross by the prosecution is about that, and they don't even talk about the case, which hasn't always been a successful strategy, but sometimes it is. I agree. When I get a new case, one of my concerns is I can have 3, 4, 5 experts that all agree it's not abuse, but they have different nuances between them. And I do everything I can to harmonize that to the maximum possible. However, our experts are independent. They don't render opinions that I tell them to render. And sometimes it's just, I agree with Sonny, you would think it could be a strength, but it can also be exploited as a weakness. And, I think a lot of it depends on who your audience is. how will the judge or the jury interpret that? How big of an issue is it? But experts,
Right.
I mean, if you have a dead baby, you need a pathologist. Do you need a neuropathologist? Does it have imaging? You need a radiologist. I do want to tell you about this one case that I had recently where the prosecutor had a forensic pathologist, a pediatric pathologist, a neuropathologist, and another pathologist who his type escapes me. We had consulted with 3 pathologists, various ones, neuro and whatnot, and everyone missed one thing. And I would actually encourage you to do this. I ended up, I had a client that had a pretty unlimited budget, and I would ask each doctor if they could recommend anyone else that could look at the case. And one of the doctors threw out this pediatric infectious disease doc. And, during autopsy, they took the blood out, and what blew out of, there were 2 things that grew out of the blood culture. One was a bacteria that's typically on the skin, so it's dismissed as, artifact or contamination. But the other was a bacteria group, in this case, it was a group B strep, that every one of the other pathologists either didn't even talk about it or explicitly dismissed it as a contamination. And this pediatric infectious disease doc calls me up within an hour of him starting to review the case. He says, "Mark, what jumps out at me in this case is this group B strep." And it had grown out in 11 hours. He said if it's a contaminant, it usually takes longer. And he said, this kid died from this. This is he called it feared organism for pediatric patients. And having had that experience, I just in the past month have reviewed another case with almost the identical thing. And I haven't gotten there yet, but I have a feeling that this bacteria that grew out is going to be what explains it. And what you have to understand about sepsis is that it can kill rapidly with these young kids, and it doesn't leave much. It can cause subdural hemorrhage. It can cause retinal hemorrhage. But if that is either not tested for or dismissed as a contaminant, I had seven experts miss it, 4 on the private side and 3 on my side, on the pro defense side.
Right.
But I also want to say, because I think we did this successfully, and I've seen TIP did it in another county that we had nothing to do with. They did it very successfully as well. Don't knock out non-regularly testifying experts, doctors who are not professional experts. I think those were our strongest, honestly. I think it was very strong to say to a judge and especially in Nashville, we have some big hospitals and we've got some big medical names, but we were able to say, you're not a professional expert and you're not a researcher. You don't have a lot published. In fact, you've never testified before. This is not how you make your living. How many babies do you see a day in your practice? How many of you referred to the child abuse team? So you're just a local practitioner who we trust with our babies every single day. In fact, you worked a shift last night. How many babies did you see last night? That was very impactful to the court. And we had that with a couple of different doctors. And I actually think that is a strong way to go, because one thing that became very clear in our case and in many others, in many ways, I think that the expert system is dead in courts. I think the way that the judges are starting to interpret this, some of the opinions that have come out recently, they're just all assuming that all experts are going to say whatever they're going to say for money, which really neutralizes a lot of value that these experts have. And so this is one of the ways that we've dealt with it, is we've stopped being afraid of people who are not traditional experts, and we're putting on people doing the work every day.
There's a couple of things I want to circle back to, and I want to try to save some time for folks who might have questions. Sunny, you had said earlier that one of the things that surprised you was going back to the original medical examiner and getting a different opinion. And I think, Mark, when we've talked about this before, you mentioned how many reversals were because the original testifying doctors had changed their opinions. I wonder, Mark, if you could talk about that a little bit, because I think there may be some, certainly reticence about going back to doctors who originally testified and saying, would you testify the same way, or how should people approach that, and what are kind of red flags to be on the lookout for?
Well, this isn't from my personal experience so much as, I've paid attention and read all the, Innocence Project and the reversals. And I would say at probably 80 or 90% from my, recollection is that someone who was involved in that case on the prosecution side changed their opinion. And I think that's probably one of the most powerful pieces of evidence you can develop is don't be shy. Go, especially if you look at the types of doctors that buy into Shaken Baby, in the pediatricians, they're all going to buy into it. But neurosurgeons, neurologists, if you look at there was one study done a couple of years ago, their belief in it is a little lower, and pathologists is below 50%. So you may find in some of those, doctors that they may be listening to what's going on and they may be willing to say, you know what, I wouldn't render the same opinion today that I did 10 years ago, 15 years ago. And if you can, I wouldn't be, I don't know what the pitfall is.
I can tell you. I have mixed feelings about this, and Anna's probably over there just shaking her head because this was another call that I take responsibility for. My teammate very much tried to encourage me to contact the original diagnosing doctor and the original medical examiner, and I was very hesitant to do that. There are strategic reasons that I think do matter that I still stand by in that. Sometimes it's we don't want to alert other people who are going to start biasing this round of opinion. And in that was my primary concern with this, is there were some very closely connected, big in the Shaken Baby world names who would absolutely have gotten on the phone and started to bias whatever they had to say. Also, as the state, I have a different responsibility. I really want to make sure I'm getting objective experts. We told every single one, look, if this is abuse, you tell us. And some of them started off leaning towards that, saying this might be abuse. And then the more they looked into the records, they would call us back and say, hey, wait, it's not. But I have second guessed more times than I can count, more sleepless nights over our decision to wait to call the medical examiner until after our hearing was done. And we did it at that point because at that point we had less to lose. And then lo and behold, he changes his entire opinion and we're in a procedural purgatory. The hearing is done. The appellate court here, here's this incredibly valuable information. I think there are strategic decisions to be made. I think you weigh that out. I do think there are some cons. I mean, when you've got people involved in these cases like we do, who are still nationwide characters on these issues, there are risks to be had. And for the state, we can't ever be looked at as experts shopping. So when we're getting these opinions, we have to look at, are we stuck with them then at that point? Now, if I had to do it over again in our case, we would have called everybody. We would have called everybody and I would have dealt with it and we would have figured it out. I stand by why we made the choice, but I do think Mark's idea of being a little less afraid of it than I was afraid of it is probably the way to go. And Anna, that's a tip to you because Anna kept telling me, let's not be afraid of it. And I was.
And actually, that's kind of the segue to the last area that I wanted to kind of talk about with you guys, which is the, hindsight being 2020. If you had to do things differently, kind of, I don't want to call it learning from losing perspective, but, from that kind of thought, Mark, I think you've talked about how important the judge is, for example. So like, what are some of the lessons that you would give to folks about cases that you've handled that you kind of would have handled differently potentially? Or are there strategies?
Again, this doesn't apply in post-conviction so much, but I mean, my big dilemma is I'm not a big fan of juries in these child abuse cases, especially when there's pathology to show this baby that's been sliced and diced. I mean, it's so emotional. I think most jurors have a very difficult time being objective. So I always try to question whether or not we should waive the jury. But aside from that, you always have the issue of, and I want to go back to what Sonny said at the beginning. I agree that if you can find a mimic of abuse that was missed, rather than head-on challenging Shaken Baby syndrome, 50 years of orthodox belief, I always want to make, they just missed it. Because here's the problem, you're in Nashville and Vanderbilt is the big hospital. So whenever a kid's sick, they put them on a chopper and send them there. So you put this jury in a position, or you put anyone, a judge making a decision, they're so incompetent that they don't even get the science. Versus, hey, they're really good. They're great at what they do. They take care of all our sick kids. But in this one case, they got it wrong. Here's why. I always feel that that's a better approach. And when you're looking at a judge, again, if you're talking about change science, now I don't think you do Daubert or Fry's when you're doing your post-conviction unless you get a reversal, then you can do it. But when I'm looking at Fry or Daubert hearings, you got to consider, is this judge A, smart enough to get it? B, do they have enough courage to make the right decision if you persuade them? You always have to consider your audience, whether it's a judge or a jury, whether it's the trial or post-conviction or a Fry hearing.
Yep. Thank you. And Sunny, same hindsight considerations?
It's hard because sure, I've already mentioned a couple of things that keep me up at night that maybe we should have done or shouldn't have done, but I don't know that that makes it different than any case. I started this job telling my boss, there's not a defense lawyer in town, won or lost, who can't look back at a case and go, man, I could have done that, or there's something else I could have done. And the reality is, even these lessons, like I said, I still can't say that 100% of the time I would go make those calls. I really think it would depend on what's going on in this case, who the players are and what's happening. And again, my role is different. I am not trying to get an outcome of innocence. I'm trying to get an outcome of, did we get it right? Did we not get it right? So we did learn a lot. I would say to power ahead with a little bit less fear, but our fear was never related to we want a particular outcome. Our fear was, the big question for CRUs always, does involving the original people, does it actually bias your current investigation? Could it actually interfere with what you're doing now? I still have those questions. So did we learn a lot? Yes. And I think it's really important to talk to other CRU directors, other innocence lawyers, defense lawyers doing this to figure out the big red flags. But ultimately, I honestly think I still stand by all of the decisions that we made. So I think as long as we have sought wise counsel and we've looked for the red flags and avoided those things, we handle these cases like lawyers, like we do any other.
And Marissa, if you're asking me if I have after the thought regrets of decisions made, I can think of two cases where
Only two? I've got them for every case I've ever handled. But
well, one issue in particular is both of these judges were openly hostile. One case I litigated in Illinois, another was here in Pennsylvania, and I talked to my client and they said, no way, seeing how hostile this judge, we waived the jury. I can tell you in both of I got split decisions out of the juries, which I get a lot, which are logically inconsistent, which means it was a compromised verdict. And I'm fairly certain in both of those cases, the judges would have done a full acquittal because their demeanor changed during the trial. Once they heard the evidence, the hostility went down and you can tell a lot by how you're treated in the courtroom. And if I have a regret, it's probably not waiving the jury in a couple of cases.
Fair enough.
And I suppose that I want to restate what I said a little bit. It's not, if there was a hindsight consideration that I actually do think that we have learned from, and I don't just mean this case, I'm not referring to just this case, but as we've done these, we have taken what we thought we knew about judges based on our combined 100 years of lawyer experience in these courtrooms. And I think, at least for me, I'll only speak for me, it was easy to think, well, I do know this judge, or I trust that they can handle this information, or that this will make sense. But the reality is, when you're talking about people who've already been convicted, maybe twice, and you're talking about dead children and a controversial subject, all bets are off about what we think we know about these judges. And so we just have to be as thorough as possible and hit every possibility regardless of that.
And while I'm waiting, so again, we have some time for questions from folks. Please feel free to put them in the chat. If you can't figure that out, just kind of raise your hand and I'll be happy to call on you. But while we're waiting for that, Sunny, you mentioned before that you wanted to get back to Mrs. Mays's case and how there's a difference of treating, I think, the spouses, to be more general about that, than particularly from a prosecutor's perspective.
Yeah, and not so specific as to her case, but what we've seen in these cases and even in these applications is how often, and we'll say that the father is the primary suspect in these. The mothers are pulled in, first of all, a very sexist and antiquated way, but it still happens. I mean, we have seen a case recently, I won't say if it's this one that we're talking about, but where a mother essentially did nothing but leave the care of her child in the care of the father. There was no other evidence. I mean, despite what the state said, there really was no other evidence that she should have known that the child was at risk or any of those kinds of things, and is still charged in this way that honestly, I haven't seen in reverse. I have not seen fathers charged in this way. And I don't think we can forget the stories of these mothers as they go along, because sometimes it's more compelling. I think that juries might have less sympathy or their own biases towards these fathers. But we think about this mother who in the same day lost her child, lost her husband, is also facing charges, and maybe did nothing but run to the store to get a snack or get some milk. And then we also can't forget the coercive nature of all of that. When the intent is to get the mother to testify against the father or to say something inculpatory, we have to look at what was the basis of the charges against her and how did this play out as the trial went on. I just cannot forget about these co-defendants because maybe they didn't go to prison. In this one, I think, you know, in couple of our cases, I think this story is critical to understanding what happened in totality in this case.
And Mark, I'm about to put it in the chat, but there was a decision that came out of New Jersey Superior Court in the Nieves case that we've discussed. And if you could kind of just tee that up for folks about why is that an important decision? Is it something that they should be reading? How could that impact, do you think?
Well, for my practice, like I said, I typically wouldn't want to challenge Shaken Baby head on and would instead focus on trying to find the alternative explanation that was missed in this case. I've become recently a lot more aggressive on the Fry-Daubert issue because of the Nieves case. And Nieves is basically, New Jersey's a Fry jurisdiction, and the biomechanical engineers have never accepted the Shaken Baby hypothesis. Every biomechanical effort to validate it has failed. And the Nieves decision basically said, although medicine and pediatricians accept it, because biomechanical engineers have never accepted it and the shaking hypothesis is a biomechanical hypothesis, the relevant scientific community for general acceptance under the Fry standard is the biomechanical community. And as a result, this is an intermediate appellate decision in New Jersey. That's currently the law. There are no Shaken Baby prosecutions in New Jersey right now that I know of. When this was argued before the New Jersey Supreme Court, the prosecutor, I think, said there were 11 or 13 shaking prosecutions being stayed pending the outcome of the Supreme Court's review of this Nieves decision. I'm optimistic that we'll get a positive result there. But, you know, I think it's something you need to look at. Like I said, I've been kind of hesitant to do it. I used to do it challenging just the retinal hemorrhage issue or, you know, some other thing. But I've in Pennsylvania now, I have 3 Fry motions pending. Well, 2, I'm going to file a 3rd in Pennsylvania where we're just going after it, saying they shouldn't even be able to talk about shaking during the prosecution.
And if I can just add on to that, I know we got to go, but if I can add on one thing to that, because it does actually go back to the hindsight and the expert. If there is something else I would never do again, we had access to biomechanical engineer experts. We had consulted a couple of experts in trauma specialists to address the statements, things like that, and the behavior of the parents on the scene. We made strategic lawyer decisions that I still stand by about not putting those experts into the record or on the stand, because we actually thought it would weaken our argument in front of the judge, that he would find a way to dismiss those experts and it would take the focus off the ones that really are the big bang for our buck. Let me tell you that if I had this to do over again, I would put every single expert on in every single area and make that record of what they had to say, regardless of how I think it might impact the trial court. Because certainly at the Court of Appeals, there's just even more new science that we could have relied on that maybe this judge would have dismissed, but actually exists and is a real thing.
Well, I don't see any more questions in the chat, so I just have to say thank you so much, Mark and Sunny, for taking the time to talk with us on this topic. Incredibly important for folks. I'm very, very grateful for your time and your expertise. And for everyone on the call, of course, we will have another meeting next month. I think we turn back to some DNA issues for the next couple of months, care of Adina Thompson, who's works with me at the Quattrone Center. She also has a new DNA attorney group meeting for next Thursday, January 16th at about 3 p.m. Eastern time, where they'll be discussing the NIST Mixture Interpretation Foundation review there. Anybody has questions about that, I just put her email address as well as my own in the chat. Please, as always, feel free to reach out to us. And thank you all for your time. And please join me in thanking both Sunny and Mark for your time and being with us. Thanks, everyone, and Happy New Year.
Thanks so much. Happy New Year.